Welcome back to Understanding the BC Roster Parenting Coordinator Participation Agreement. In our last episode, we talked about what happens when one parent refuses to participate and why parenting coordination is designed to continue functioning even when cooperation is imperfect. Today, we're going to discuss another question that comes up frequently during intake meetings. If I have a parenting coordinator, why can't I just go to court whenever I want? Some parents are surprised to discover that the participation agreement contains provisions that expect them to use the parenting coordination process rather than immediately returning to court for every implementation dispute. That doesn't mean you've lost your rights. It also doesn't mean the parenting coordinator replaces the court. In fact, understanding how parenting coordination and the court system work together is one of the most important things a parent can learn before signing the agreement.
Okay, Corey, let's start with a question that might make some parents nervous. Am I giving up my right to go to court?
No, that is probably the biggest misconception about this section of the agreement. Parents do not sign away the court system. The court remains the ultimate authority. What the agreement generally does is require parents to use the parenting coordination process first for issues that fall within the parenting coordinator's jurisdiction while the appointment remains active.
Why not let parents decide whether to use the parenting coordinator or the court?
Because parenting coordination would become much less effective if every disagreement immediately resulted in litigation. Imagine two parents who disagree about a school issue. They bring the issue to the parenting coordinator. At the same time, they file court applications about the very same issue. Now, there are two processes happening simultaneously. That creates delay, confusion, duplication, and additional expense. The agreement attempts to avoid that situation by encouraging parents to use the parenting coordination process for issues that fall within the parenting coordinator's authority.
In other words, the agreement is trying to prevent two people from doing the same job?
Exactly. The participation agreement is designed to reduce repeated court applications concerning implementation disputes. If parenting coordination is going to function effectively, the process needs an opportunity to address the issue before everyone runs back to court.
Can you give an example?
Imagine the parents disagree about a holiday schedule. One parent contacts the parenting coordinator. The next day, the same parent files a court application about the same dispute. Now, there are two separate processes trying to address the same issue. The agreement attempts to prevent that kind of duplication because it tends to increase conflict, increase costs, and delay resolution.
Let's talk about the situation that probably worries people most. What if I think the parenting coordinator got it wrong?
The participation agreement specifically preserves review rights. Determinations may be subject to legal review processes. Parents sometimes assume a parenting coordinator's decision is final and unchallengeable. That isn't how the system works. The agreement repeatedly recognizes the continuing role of the court and the availability of review mechanisms.
That's an important point. The court never goes away?
Correct. The court remains the ultimate supervisory authority. Parenting coordinators exercise delegated authority within a defined area. The court continues to exist above that process. The court retains important roles in relation to review, enforcement, and matters that fall outside the parenting coordinator's jurisdiction.
If I'm listening as a parent, I might wonder, what kinds of issues still require the court?
One way to think about it is that parenting coordination generally focuses on implementation issues that fall within the parenting coordinator's authority. There are also matters that remain outside that authority and continue to require court involvement or another appropriate legal process. The agreement specifically recognizes that the parenting coordinator's authority is limited and that courts continue to exercise authority over matters beyond those limits.
Suppose I don't like a determination. Can I simply ignore it and ask a judge to decide instead?
Generally speaking, the structure of the agreement is different. The expectation is not, "I'll comply only if I agree." The expectation is that parents participate in the process and comply with agreements and determinations, while preserving whatever review rights may be available. Parents often confuse disagreement with invalidity. Those are different concepts.
Some listeners may still wonder whether parenting coordination is just private judging by another name.
No, that's not what the participation agreement creates. Judges and parenting coordinators perform different functions. Judges exercise judicial authority. Parenting coordinators assist with implementation and may exercise delegated authority within defined limits. The agreement repeatedly reinforces that the court remains the ultimate authority.
If courts remain available, why use parenting coordination at all?
Because many implementation disputes are not well suited to repeated litigation. Parents can find themselves returning to court over relatively small but recurring issues. Parenting coordination is intended to provide a structured process that can address many of those disputes more efficiently and consistently than repeated court applications.
Here's another practical question. Can parents simply call the parenting coordinator as a witness every time they return to court?
The participation agreement addresses that too. The agreement recognizes that parenting coordinators are not parties to the dispute. The parenting coordinator's role is outside the courtroom. They are not experts or witnesses in that role. Appearing in court often undermines the neutrality that parenting coordination is intended to provide. A parenting coordinator's determinations, recommendations, and reports should be written to stand on their own without requiring the parenting coordinator to become directly involved in the litigation. Court attendance, production of records, responding to subpoenas, and participating in legal proceedings involve additional procedures and costs. Many parents incorrectly assume they can automatically obtain the parenting coordinator's entire file or require unlimited participation in litigation. The agreement creates protections around those issues. The agreement also provides that if a party seeks to compel the parenting coordinator's participation in legal proceedings, the parenting coordinator's fees, legal expenses, disbursements, travel time, waiting time, and preparation time must generally be paid in advance. This reflects the reality that responding to court proceedings can require significant time and expense, including the retention of independent legal counsel. The purpose of these provisions is not to prevent legitimate court review, but to preserve the neutrality of the parenting coordinator and to discourage unnecessary involvement of the parenting coordinator in the parent's ongoing litigation.
After all these years, what's the biggest misunderstanding parents have about the relationship between parenting coordination and court?
Many parents assume there are only two possibilities. Either the parenting coordinator controls everything, or I can go straight to court whenever I disagree. The roster parenting coordination agreement actually creates a middle ground. The parenting coordinator helps address implementation disputes within delegated authority. The court remains available as the ultimate supervisory authority. Both systems exist at the same time and are intended to work together.
So what's today's most important lesson?
The participation agreement does not replace the court. It creates a structured process designed to reduce unnecessary litigation while preserving the court's continuing role. Parents aren't giving up the legal system. They're agreeing to use a dispute resolution process before returning to court on issues that fall within the parenting coordinator's authority.
Today's discussion answers a question many parents have when they first see the litigation provisions. The roster's parenting coordination agreement isn't taking away the courthouse. It's trying to make sure parenting coordination has a meaningful opportunity to work.
Exactly. Parenting coordination and the court system are not competitors. They're different parts of the same broader family justice system. Understanding that relationship helps explain many of the provisions throughout the agreement.
Next